What is really going on in the Idaho 4 Kohberger case, and what flurry of paperwork is obstructing our view of all of that?
13 motions? You don't have to be a law professional to know that is a crazy amount of documentation. I'm Lainey Law.
And I'm attorney Andrew Myers.
Andrew, you are going to need to break this down for us because I can't even begin to wrap my head around 13 motions. What is this all about?
Well, the day we're recording this podcast, I had plans. I had made an outline, and I was working on what's really going on in the Kohberger case. And I opened up my computer and I went online to the Idaho docket, as I did yesterday. There's nothing really new yesterday. So I come in this morning and there are that many motions that have been filed in the case. And I'm saying to myself, oh, good grief, I'm going to have to start from scratch. So that's what I did. I tore off my paper, threw it in the trash, and started all over again. And, I know there are people on the computer who will read all of this for you. And yeah, I read it all. I did read it. But I don't know. Even though I'm an attorney and I've been practicing for all these years and I went to law school and read a lot of books, all of them. I don't know. I find it a little bit tedious going through the motions from start to finish. And it definitely wasn't going to be appropriate today when there's so much to get through. It's all about the death penalty. It's all about Bryan Kohberger's attorneys are vigorously challenging the imposition of what we'll call the DP from now on in this episode. So I thought I'd break it down. I'm going to give you everything you need to know in 6 PowerPoint slides. Did I say 6 PowerPoint slides? And then, yes, we'll get to some of the motions because I know a lot of people are interested in some of that. So the summary of it all is this. In order for one, after they're convicted, of course, to have this penalty imposed upon them, there are 5 aggravating circumstances which the jury will be asked to look at. And those 5 aggravating circumstances are, and this is a summary, folks. This is the Craigslist version. I got through law school at the top of my class and passed the bar exam the first time with the Cliff Notes version. So we've kind of boiled down the 5 aggravating circumstances. So if you go to the law books, you'll see that we've changed the wording to make it easier for all of us to understand. Aggravating circumstance number 1, at the time the crime was committed, the defendant also committed another crime. And there's the citation if you want to look to the law books. The crime was especially heinous, atrocious, or cruel, manifesting exceptional depravity. 3, defendant exhibited utter disregard for human life. 4, the crime was committed in the perpetration of or attempt to perpetrate one of a number of listed crimes included but not limited to robbery, burglary, or mayhem, and the defendant acted with reckless indifference to human life. And if you'll remember, in this case, people that have been following the case a lot, Mr. Kohberger was indicted on 5 counts, 4 counts for the unalivings of the 4 University of Idaho students, but then one of them was robbery. So that's why they did it, for this aggravating circumstance. And the 5th one is that the defendant, by his conduct, whether such conduct was before, during, or after the commission of the crime, exhibited a propensity to commit such crimes, which will probably constitute a continuing threat to society. So Ann Taylor has filed a motion with the other defense attorneys, saying, look, first of all, we think all of these should be struck. So that's 5 motions right there, because there was 1 motion for each of those. So then the next thing that Ann Taylor said was she wants to trifurcate the trial.
Trifurcate? What the heck is trifurcate?
Well, this is a nuance. This is a nuance. Our attorneys and our true crime devotees will know what a bifurcated trial is. In other words, you go to a trial for serious charges like these, and it's broken down into 2 phases. The first phase is guilty or not guilty. And that's all it is here's the evidence, here are the charges. Based on the evidence that's been presented to you, jury, is he guilty or not guilty? If he's not guilty, the end. If he's found guilty, then you go to the next phase, which is imposition of the death penalty. So that's your bifurcated trial. And Taylor says, no. We want to trifurcate it we'll keep phase one the same. Phase two, we're going to break into two different phases. And the first phase is A, whether the defendant is eligible for the death penalty. And so now they go down through those 5 factors we just told you. And B, what is the appropriate punishment? Are we going to go with the DP, or are we going to go with life in prison or some alternative? Now, it's hard to think that anything other than the DP or life in prison based on the allegations in this case. But again, these are allegations. So now that is, I just told you about 6 of the different motions. And I'm going to break it all down. Then we will look at some of the wording. Among Kohberger's defense attorney's arguments against the DP are their claims that Idaho has no viable method for executing a prisoner in a capital punishment case. The state's method for obtaining a DP punishment is unconstitutional, they say. A capital murder case cannot be prepared in 10 months, and the death penalty violates the prohibition against cruel and unusual punishment. Among the various arguments, Kohberger's attorneys wrote, Idaho's system of obtaining death convictions is unconstitutional at this time, and that the state's guarantee to a speedy trial prevents effective assistance of counsel in death penalty cases. They go on to argue that capital cases must be subjected to heightened constitutional scrutiny and cannot be prepared in 10 months. Bear in mind that we added this in. Kohberger's trial is now scheduled to start on June 2nd of 2025, which to me seems like forever, because summer is the fastest season and then winter just drags on. I mean, you go into the holidays, they're here and gone. Then you get in, at least if you're in New England, you got January, February, March, and you're shoveling snow and clearing ice off the windshield and all of that. And then all of a sudden you're at June. So.
Yeah, no, I mean, I definitely agree with that. It's hard. I mean, I can't even imagine. Obviously, attorneys have a job to do, and everybody's going to be doing their jobs in November and December, but it's a lot to get ready for. It's a lot to get ready for when there's a lot of things going on in the world. So, I mean, June will be here before you know it. I know we've been talking about this case for a long time and how it keeps going on and on and on, but I mean, did we really think we'd be in September at this point? I don't know.
I don't want to take bets. I'm not a betting man, but I would love to hear what our viewers, a lot of whom are devoted to this case, because I know that because they ask us some really penetrating questions and they give us some penetrating critiques too. Oh my gosh, some of the stuff we hear. So I want to ask you, whether you've been following this case or not, do you really think the case will go on June 2nd? I really wonder. But anyhow, 2 final notes I want to make here before we head into the actual documents is, I don't know if you remember back in March of 2023, which was several months after the Idaho 4 slayings, Idaho governor signed a new law allowing a firing squad in Idaho if lethal injection drugs are unavailable. Because when the drug companies found out that their drugs were being used to impose lethal injections, a lot of them pulled back, or if they knew that the order was from a state and that was their intent to use it, they wouldn't supply the drug. So that's interesting note number 1. Interesting note number 2. I don't know if you remember this, but back in February of 2024, Idaho's attempt at execution by lethal injection of 50-year inmate convict Thomas Eugene Creech failed after a medical team repeatedly 8 times failed to find a vein where they could establish an intravenous line.
Oh my God.
So imagine this. They wheel the guy. He's in his 80s. They wheel the guy out to the room and they strap him down. And it's like, I don't know if you ever gave blood and they had a hard time
That's
finding
me
the vein.
every time. This is like a new fear unlocked. I, hopefully never get convicted for any crime, but it's like I can't. I don't even like going to the doctor's office to give blood because every time that I need to do something, I went for surgery recently. It's just like they can't find anything in my arms. They have to go through my hands. If they try to just go through I have to tell them they have to go through my hands if they can't find the arms. And even then, when they know what they're supposed to do, like it's still so hard. I cannot imagine for lethal injection, they're trying 8 times. Makes me want to throw up.
And it's not for a hopefully beneficial purpose. You went in for surgery. I go in for a medical thing that I'm going through, which I'm fine. Don't worry about me. But they, I have to give blood every now and then, and I'm lucky that people say I'm full of it, but I'm full of blood because it just it gushes right out. It's rare with me anyhow that I need to have them do it twice. But I'm one of those people, when she's over there trying to give me the injection, I'm looking over here because I can't stand the sight of a needle. It's like, so, but if they were trying to, unalive me and it took them 8 tries.
Oh my God. After the third time, let them go.
Guys, just give me a gun. I hate to make light of this because it's not funny.
Oh, it's mortifying.
But I mean, come on, Idaho.
It's, it's so grim that it's humorous. It's just like,
it's called dark.
Yeah. It's just like 8 tries. Oh my God. 5. I can't imagine being 5. Oh.
So the guy's still alive, as far as I know. He's elderly, and he's still alive. So, all right. So we promised to summarize everything, and we've done that. But now I would kind of like to take a look at some of the pleadings, and this is the motion to strike the death penalty on the grounds of the speedy trial, preventing effective assistance to counsel. The issues identified by Ann Taylor were that Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and constitution. And in Idaho, the right to a speedy trial is defined by the law as it was at the time of the adoption of the Constitution. The Idaho Constitution guarantees a speedy trial except where there is good cause for a delay or the request for postponement came from the defendant. And if you'll remember in this case, at the last minute, Kohberger and or his attorneys waived his right to a speedy trial. The Idaho Constitution requires a fixed amount of time to constitute undue delay. This court, Taylor says, should adopt the 6-month line adopted by our legislature. A defendant in Idaho can never request additional time without losing his right to a speedy trial. A capital case cannot be prepared in 10 months. Idaho cannot force a defendant to choose between his rights. So remember, we said that in our summary in the top.
Mm-hmm.
The procedural history, as we know, on December 13th, 2022, law enforcement found Madison, Mogen, Kaylee, Goncalves, Xana, Kernodle, and Ethan Chapin. On December 30th of 2022, law enforcement arrested Mr. Kohberger at his parents' home in Pennsylvania. Mr. Kohberger's current counsel filed for a limited appearance the same day. His first appearance in court in Idaho was January 5th, 2023. On January 12th of 2023, Mr. Kohberger filed a notice of appearance, request for timely preliminary hearing, motion for bail reduction, and notice of hearing, which contained a demand for speedy trial pursuant to the 6th and 14th Amendments to the United States Constitution. And she goes into a little bit more detail on the history that I know our viewers know. Argument: Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute in the Constitution. Pursuant to the Idaho law, a court must order the prosecution or indictment to be dismissed unless good cause to the contrary is shown. If a defendant whose trial has not been postponed upon his application is not brought to trial within 6 months from the date that information is filed with the court, when a defendant invokes their statutory speedy trial right, is not brought to trial within 6 months and shows that the trial was not postponed at his request, the burden then shifts to the state to demonstrate good cause for the delay. So she goes into a lengthy legal explanation. And I just want to, because we do have other pleadings to take a look at, I want to go down and show you her conclusion. And unlike other times, we are not going to read all the footnotes. Based upon the foregoing, an argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that A, the state's notice of intent to seek death penalty be struck. B, the court seat a jury which is not death qualified. C, the court preclude the admission of any evidence of aggravating circumstances during the trial of this case. And D, the court not instruct the jury on any aggravated punishment. So you've seen Kohberger's attorneys really pick away at every detail in this case. Venue, they picked away at. They've been picking away at the DNA. They've been picking away at the discovery. And so this is just their latest attempt to just really pick the case apart.
It's a big ask. It seems like a big ask. It sounds like they're trying to do a lot at once, at least here. I mean, they've been trying to consistently do a lot with this, and obviously it's their job to not get their client to death penalty. This is a huge, I mean, it's an overwhelming amount of information. It's a huge update right now. And do we think, now I'm curious of what you say, because it's the request for the motion. Maybe I should wait till the end to ask what you think about that. No, I'm just curious. It's just like, do you think that there's any chance that the judge is going to go with this motion? Or at least the previous, It was like the judge has already been having
Let's ask our viewers, what do they think, if this is going to be allowed or not? I'll only say this, and that is that you know how they say these cases last forever? This is more laying the groundwork for an appeal. Because the United States Supreme Court, does occasionally visit the death penalty, and whether it's consistent with the 8th Amendment of the Constitution, which outlaws cruel and unusual punishment, and that was a real battle that's been addressed. But the U.S. Supreme Court is always open to revisiting these issues that are just really very topical, and it's a major issue, not only legally, but socially, morally, religiously. It's just on a lot of different levels. So I don't have a crystal ball. I can't say outright that the judge is not going to allow any of this, but if he doesn't, I said this last week, and I better stop saying this because I'll be homeless. I would bet my house that these are appeal issues. These are, in fact, appellate issues. So now, do you remember I had those 5 different aggravating circumstances up at the very top of this presentation? 5 aggravating circumstances that would allow the jury to then go to the second phase of the bifurcation or the third phase of the trifurcation to determine that they should impose the DP. Well, one of those 5 was utter disregard for human life. And so this is one of the 5 motions. This is the motion to strike utter disregard as an aggravator. And I brought this one up only because, it is, in fact, one example. All 5 of them, obviously cited different law, different research, different facts, but they all followed, pretty much the same pattern. Comes now Bryan Kohberger, by and through his attorneys of record, hereby moves this honorable court for an order striking from the state's notice pursuant to Idaho law the allegation that the unaliving itself or by its circumstances showed an utter disregard for human life. This motion is made on the grounds that this aggravator is unconstitutionally vague and fails to narrow the class of eligible candidates for death. Okay, so in constitutional law, there are a lot of reasons why you can strike anything the legislature does. Anything the legislature does. The legislature can pass a law tomorrow saying the sun will come up in the west and set in the east. If it falls under some categories, like it's absurd, like that example, the courts could override the legislature. So one of the grounds is void for vagueness. If a statute passed by the state legislature is vague, it can be declared void. So that's what she's going for here.
But I see it's interesting because I feel like it's not super vague. I feel like I don't know. My interpretation of that, like, I feel like she's made a lot of good arguments in the past, but I feel like that one is one of her weaker arguments.
Well, I don't know. What is utter disregard? What is utter disregard? What do those words mean? It's a generality.
Yeah.
It's not specifically saying if you engage in this conduct, A, B, C, D, or E, granted, it's a bit of a stretch, but what she's saying is, what is utter disregard? If I go home tonight and I'm told, cook a dinner, and instead of cooking the dinner, I go and drink a beer, and then an hour later cook the dinner. Is that utter disregard? Stupid example. I agree. Stupid example, but
it's like me in class. It's just like looking around, browsing while we're supposed to be paying attention. Utter disregard. I guess I can empathize with.
So she goes into a lengthy history to make her case. The U.S. Supreme Court has stated that the Eighth Amendment's prohibition against cruel and unusual punishment, made applicable to the states through the 14th Amendment, prohibits a state from imposing the DP in an arbitrary and capricious manner. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and persons against whom the death penalty is imposed. And I think she wrote that sentence for you because what she's saying is that the Supreme Court said, we're not favoring the DP anymore. And if you do it, you've got to have specific standards. So she's saying that this isn't specific enough. To pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others who are found guilty of unaliving. That all having been said, the aggravating circumstances in this case must meet two requirements. The circumstances may not apply to every defendant convicted of unaliving, and it must apply only to a subclass of defendants convicted of unaliving. And so she goes on, and I often say that the real meat of these things is in the footnotes. This case is the exception. We'd be here until next Christmas reading through them all.
Oh my God.
But my point is that, of the 5 grounds, she's trying to get rid of all 5 of them. I'd be surprised if maybe she gets one of them. But anyhow, the judge might say, okay, you're right on 1 and 2, but we're going to allow the jury to hear 3 and 4.
I don't know. The whole thing is weird. It's hard because it's like, even just reading this, I'm trying to like justify it in my head because I'm like, well, what is grounds for the death penalty? And when I think about it, I would think, only reoffenders would be eligible for the death penalty. But in this case, you have a quadruple homicide. And it's like, if he killed 4 people, presumption to innocence. But if he killed 4 people, then, some would argue that he doesn't care about human life and that would justify it. I think I'm with a good portion of our audience right now when I can't even it's like gravitating towards like the thought killing 4 people is just like, I don't even know how they're going to argue that he did it all in such a short span of time. That's where I'm still stuck at. I'm like, well, could it be the death penalty? Like, is it, like you said, disregard, where it's like we don't even know really what disregard is. How do you prove that? Is it a repeated offense? It happened, theoretically 4 times, but I don't even know how they're going to get to prove that he.
Well, it's like any other legal issue. It's like any other legal issue. There are arguments to be made on both sides, and what the prosecution will most likely argue. I'm not in their heads. I can't say what they will argue, but what they will most likely argue is that utter disregard would cover a category where one person goes in and unalives 4 people at the same time under the circumstances which we don't know, but the circumstances that we think occurred at 1122 King Road in Moscow, Idaho, back on November 13th of 2022. It would seem that would be their argument, but we don't know. And I have to give credit where credit is due. The motion is written not by Ann Taylor, but by her colleague, Jay Logston, one of the other public defenders. So that's that motion. And then another really interesting thing. Do you remember the venue hearings and motions and whatever?
There were
5 experts, right? 1, 2, 3, 4, and now we have 2 new experts in the case.
Another one.
2.
Another 2.
Yeah, these are DP experts. Comes now Bryan Kohberger, by and through his attorneys of record, and pursuant to the Idaho Criminal Rule 16, makes the following expert witness disclosures. Barbara Wolf of Leesburg, Florida. Dr. Wolf is expected to testify to the findings outlined in her affidavit filed with the court on September 5th, 2024, in the defendant's motion to strike the state's notice of intent to seek the death penalty on grounds of vagueness in balancing aggravators and mitigators. Remember, I said that void for vagueness is one of the grounds upon which a statute can be invalidated. Well, and her curriculum vitae is attached, and it basically shows that she has extensive experience in studying these issues. And that would be a whole nother episode. And then another expert is Eliza, I hope I'm pronouncing that correctly, Eliza Plenner-Cover from Boise, Idaho. A complete statement of all opinions to be expressed and the basis and reasons therefore are contained in Ms. Cover's law article, Narrowing Death Eligibility in Idaho, an empirical and constitutional analysis. And we would be here until next Christmas if we read all of that, but it basically just, what they're trying to say is that they need expert testimony to support their allegation that the grounds upon which the prosecution seeks to impose the DP are void for vagueness. And there are more specific statutes in other states. And the Supreme Court has said that, yes, the DP is a violation of the 8th Amendment for being cruel and unusual if it is not imposed under specially defined circumstances imposed by the court. So I've just condensed about 150 pages.
Oh my God. Thank you so much for doing that for us. Although I'm sure a lot of people watching have carefully combed through every single detail of it, but it is a lot to digest. It's a lot at once. And
if any of our viewers have read every single page of all of the attachments and affidavits and law review articles and footnotes, comment down below. We'll bring you on. We'll bring you on and have you,
I was going to say send in their applications to work in your office.
Yeah, because I could use a long vacation. And I mean a long vacation.
It's like, we'll have you guys read through the documents and set up the docket for today because, oh my goodness, that was an insane amount of information to process. And I think, as we've been talking about with a lot of this stuff, a lot of it is just kind of building up and preparing for appealing later on. So, Oh,
you thought you were done? You thought we were done?
No.
Oh, no, young lady, we are not done. We have 2 more. We have 2 more.
I know, thank you for reading through these and finding this stuff for us. But yesterday I had a meltdown because I had to read 20 pages for homework. I'm like, oh my God, you want me to read a textbook for 20 pages? And here we are, hundreds and hundreds and thousands and millions, what feels like pages in. And this is only all the documents for one day.
Well, don't go to law school because we would regularly be assigned. First year, they try to kill you.
Oh my God.
And they didn't. First year, they give you 250 pages of reading every night.
Every night.
Yeah, right.
Oh my God. No,
after taking Evelyn Wood's speed reading class and talking to other people in a study group, you read those pages, I'll read those pages, you read those pages, then we'll all meet and get together. And learning that people don't do their homework and that you have to do it all yourself anyhow, I discovered they have case summaries. So instead of reading 250 pages, professors, turn down the volume. You can get by reading the summaries. Okay. I was at the top of my class. So
there you go. This is award-winning information there. Use your time wisely. Work smarter, not harder.
Exactly. Anybody that sits down and reads, I'm not a fast reader. Anyhow, so this is the motion and memorandum in support of the motion to trifurcate the proceedings and apply rules of evidence during the eligibility phase. So this is where we spoke. And she wants to not bifurcate the trial, but trifurcate the trial. Comes now Bryan Kohberger through his attorneys of record and hereby submits the following motion and memorandum in support of the motion to trifurcate the proceedings and apply the rules of evidence during the eligibility phase. Proceeding with a bifurcated trial in which non-statutory aggravation is presented without the rules of evidence being applied will result in a violation of Mr. Kohberger's state and federal constitutional rights, including the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 1, Section 6 and 13. So, Idaho's death penalty scheme, and this gets to what I summarized earlier. The death penalty scheme in Idaho, and most states actually, provides for two phases. The first, where culpability of the accused is determined, guilty or innocent. And then if they are found guilty, a sentencing phase, commonly called the penalty phase. So we have phase 1, guilty or innocent, phase 2, penalty phase. Again, standard in most states, every state I've been involved in. But anyhow, problematically at the penalty phase, the jury must actually make 2 determinations. These 2 determinations are 1, whether the defendant is eligible for the death penalty, and 2, what is the appropriate punishment. And under Idaho law, a person is only eligible for the death penalty if the jury finds beyond a reasonable doubt at least 1 statutory aggravating circumstances. So now we get back to the very first slide we showed a while ago. If you're still with us, and I hope you are, you need to find 1 of those 5 aggravating circumstances that we went over before. And if the jury determines that the defendant is eligible for the death penalty, then it must decide if it is the appropriate sentence. Where a statutory aggravator is found, the defendant shall be sentenced to unaliving unless mitigating circumstances which may be presented are found to be sufficiently compelling that the death penalty would be unjust. She cites the law. In order to sentence a defendant to death, both findings, eligibility, and appropriateness are required. The jury shall not direct imposition of a sentence of death unless it unanimously finds at least 1 of those statutory aggravating circumstances and unanimously determines that the penalty of death should be imposed. Combining these 2 distinct determinations into 1 sentencing proceeding violates a defendant's state and federal constitutional rights. This has become increasingly clearer in recent years, given the Supreme Court's holdings in, and then she cites a number of Supreme Court cases. And so she then goes through these aggravating circumstances and points out that in her belief, she believes that it would be very confusing for the jury to have to go through all of those 5 aggravating circumstances, which we only summarized. We gave the bullet points, but for the jury to have to go through all of those and at the same time then determine the application of the sentence, too much. So trifurcation of the proceedings, it is said, is necessary to protect Mr. Kohberger's state and federal constitutional rights. Mr. Kohberger respectfully requests that this court grant the motion to trifurcate the proceedings into a guilt, eligibility, and sentencing phase. Mr. Kohberger also asks that this court apply the rules of evidence to the guilt and eligibility phases. And again, my apologies to Jay Logston, one of the very good public defenders who's on this case defending Mr. Kohberger, because I think I credited Ann Taylor, who's one of his other attorneys. So anyhow, that is the memorandum in support of trifurcating the trial.
Oh my goodness. I feel like the bifurcate was already a step, obviously in a situation like this, you want to have as many steps as possible to make sure that things are being done properly. But from the bifurcate to the trifurcate, we alluded to this before, you're going from 2 to 3. And, I think I mentioned this before where you think this is all mostly build up for the appeals court. And I think in this situation, it's appropriate. I don't even think, my goodness. I just feel like the court has been so uncooperative with the defense that I can't imagine any of this really having a lasting impact. But at the same time, with something as serious as the death penalty, you're going to try to do as much as you can. If you can break it up, setting kind of almost like a cushion where it's Like, okay, you know, take step 1. Now you take step 2. Now you got step 2.5. Like, are you guys really sure you want to do this?
Well, I think what the process, to be fair, and I know I always get comments, people say that we're on, I hate this. People say you're a Kohberger lover when all we're doing is reading the motions and trying to explain them, especially where I see other people on this channel, not this channel, but other channels doing the same thing. All we're doing is explaining the law. So some people, when we do that, call us Kohberger lovers. And then if I do what I'm about ready to do and try and, you know, anticipate what the prosecution will say, you're against Kohberger, you're for the crooked state. And it's no, I'm not for anybody. I'm just trying to explain. I really am. So listen to the whole episode, comment down below. Let me know what a jerk you think I am. But anyhow, so what I'm going to anticipate that the state will argue, either Bill Thompson or Ashley Hush Jennings, that they will argue that, you know, look, why complicate this? Why divide it into 3? Bifurcation has been a long standard in most states, and the judge is going to manage it. The judge is going to manage the hearing. He's going to say, here are the 5 grounds, jurors, decide whether one of these applies. Then come back to me, and then we'll decide what to do with that information. And judge will say, yeah, that's personal. That's reasonable. Fine. I mean, why? We already pretty much do that in practicality. Why change the form? So that's my anticipation of what the prosecution will argue, and that's my anticipation of what is likely in the case. But do I have a crystal ball? No. One more pleading. This is what's called a motion for a court order requiring the state, 1, to provide notice of every alleged non-statutory aggravating factor or circumstance it may rely on at any sentencing trial, and 2, to provide beyond a reasonable doubt every alleged non-statutory aggravating factor or circumstance. So basically what she is saying in this motion is that, 1, that the prosecution provide the defense with notice of any non-statutory aggravating factor or circumstance, and 2, that the prosecution be required to prove any such non-statutory aggravating factor or circumstance beyond a reasonable doubt to the unanimous satisfaction of the jury before any juror may consider an alleged aggravating factor or circumstance as a reason to support the death sentence. This is almost like discovery. What she's saying is if the court or if the prosecution is going to present circumstances, she wants to know about it now. Because as you know, from one of the previous hearings, she said she's already had to hire an expert for the mitigation phase, for the sentencing phase. So she's already working on that. So what they want to do is have notice of any information that they're going to provide so that they have a chance. And so that's pretty much what that motion is asking for. So that is 5 or 6. I've lost count of the 13 motions that have been filed in the case. And I think that's the essence of it. And there will be a hearing on November 7th. November 7th, the court will hear all this. So hopefully by then we will know what's happening with venue, and then they'll move on to this.
I don't know how the defense is going to have time to make their argument when they have spent so much time and resources into all these documents. And, you know, I know that it comes quicker than we like to admit, but November also seems so far.
Well, they've got 3 attorneys. They've got Ann Taylor. They've got Jay Lagston, and they've got Eliza Massoth. I always call her Elizabeth. It's Eliza Massoth. So they have those 3 attorneys, plus, you know, they've got staff. Mm-hmm. And most attorneys, you know, have a staff that they meet with, and they say, this is the big picture. Let's break it into pieces. Each one of you, each clerk, each paralegal, each intern, take a piece and take a look and write something. And then the supervising attorney, not necessarily one of the 3 that I just mentioned, a supervising attorney will go through it and read it and site check it and make sure it's perfect. And then it goes up to one of the 3 I just mentioned, and they do the same thing. They read it and site check it. And I've actually site checked a lot of the pleadings. And as you know, in one episode, I caught something being, not by these attorneys, but I caught something being misquoted. And I brought it out in the episode. So they don't want that. I'm just one guy here in my office. When you go before a judge, the court then vets all of these pleadings. The court has its own staff and clerks and interns and everything else, and that's their job. So you're right. It's quite an undertaking. I'm a little bit surprised the extent to which all of these motions, 13 of them, only less than half of which we took a look at today. I'm surprised at the extent of it. Then again, it's a death penalty case. In a big case, it's a death penalty case. So, I mean, if I were accused of such a thing, which I never have been and never will be, I would certainly want a team of lawyers working full time on it. And that's what we see. That's what we see. So in the beginning of this episode, I said, this is really obstructing what's really going on in the case. And so I feel, since I kind of mentioned that at the beginning of the episode, a lot is going on in this case. The state's discovery deadline is now passed. It was on September 6th. That's now passed. There was a 17th request for discovery, and the state did respond. And it was almost all just referring to other discovery requests in the past. But there was some new material. Of course, the new material was sealed. So that's why I say there's a lot going on in this case that we don't know. The discovery that was in fact revealed just before that September 6th deadline was sealed. So was it a discovery about the informant, the secret informant, which we know there is one. We just don't know who it is. Was it more material about the two that I've always felt held the key to this case? Was it something from Dylan? Was it something from Bethany? Was it new video? There's been a lot of controversy and discussion about, where's the real video? There's no video showing Kohberger's car driving up to the house and Kohberger going in. Yeah, there's fuzzy wuzzy was a car driving around on one of the channels in the middle of the night. But in a college town, for a car to be driving around in the middle of the night, I remember my college days, we did some crazy stuff in the middle of the night. So there's a lot going on in this case. There's a very great deal going on in the case. And by focusing on this stuff, are we diverting attention away from what's really going on in this case? So that's for our next Kohberger episode.
Yeah, thank you guys. If you made it up into this point, please be sure to comment, like below, and let us know what you think. Let us know your predictions. It's been taking a lot of twists and turns, but I'll let Andrew take it to the grocery store.
Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.